Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And before I get into this video, I want to thank those of you who have purchased a copy of my novel, Love Like Snow in Florida on a Hot Summer Day. And then also someone reached out to me and said, Tracy, you know, when you're doing your videos, you're not on the videos that much anymore. And so people know that you're just showing images in the video. So they may not know that you're selling your book or promoting your book in the video. They just hear the music and think it's part of your intro. And so you need to say something on your video. So I'm saying something on the video. For those of you who don't know, I am a published author. I actually have 3 books that I published, and I'm in the process, you know, because when you know better, you do better. So I'm in the process of redoing my 3 earlier works before I put out new material. And so I re-released this novel, Love Like Snow in Florida, recently, about 3 or 4 months ago. And so now my books are going to sponsor my YouTube videos. And so if you're interested in supporting my channel, I don't ask for donations. People ask me all the time, you know, what's my Cash App? I don't have a Cash App. But if you want to support my channel, please do so by supporting my books. 2 of them are currently on the market. You can find them on my website or on Amazon. And all that information is below in the description. And if you are a reader and use Kindle Unlimited or know someone who has Kindle Unlimited, you can actually download my books for free. And then I get paid as you're reading the book. For every page of the book that you read on Kindle, I get paid for the book that way. So let's go ahead and talk about what this video is about. I went into the Eastern Missouri court records looking to see if there were any updates in the Tim Norman case. And there were several motions that had been going on since I last brought you guys an update earlier this year. And as I was reading through the motions, it got me to thinking about R. Kelly and his case. And I was thinking, wow, these attorneys need to be on R. Kelly's case or consulting with R. Kelly's attorneys, because they keep getting this case pushed back, getting more time to file information, you know, about the charges on the case. And I'm going to talk more about that at the end of the video, and about getting discovery stricken from the case. The judge actually allowed them a set amount of time. They're saying that the discovery is so overwhelming that they need more time. And so whereas they were supposed to be filing their motions to have charges stricken, to have discovery stricken from the case, that was supposed to take place this month. Now they have been able to push that out to the end of the year. And so I just want you guys to see the comparison of how his case is playing out versus how R. Kelly's case is playing out in terms of asking for more time, the new defense not having enough time to, you know, to meet with him, to go over discovery, the fact that he's been locked up for 2 years and Steve Greenberg has sat there, hasn't been going over information with him. And so basically it's like they're starting from scratch, and the clock needs to be reset from the beginning to give R. Kelly's defense more time to meet with their client and to file these motions. And so, like I said, I talk more about it at the end, but I just wanted you guys to know that I'm bringing you this video just to read these motions so that you can see that, you know, requesting more time is common in these court cases, and that, you know, the judge and the prosecutors in Tim Norman's case are very different from the judge and the prosecutors in R. Kelly case. So let me go ahead and get into the content of this video for you. Tim is the son of Robbie Montgomery, who owns the Sweetie Pie's restaurant franchise. And I am going to drop a link above letting you know what all this is about if you haven't been following this case. But basically, Tim has been arrested along with 3 other people in connection with the murder of his nephew, Andre Montgomery, which took place, I believe it was in 2016, just coming up with that off the top of my head. But he was the ringleader, or being charged with being the mastermind, I should say, behind a murder for hire plot that led to the death of Andre. But you can get more information on the link that I have placed above from other videos that I have done. And so not a lot has been going on with this case. I believe it's been probably 3 or 4 months since I brought you an update, and it really wasn't much to talk about then. Basically, Tim has been strategizing and filing motions to delay the trial. And the reason I wanted to come and share this information with you all is just to show a juxtaposition in how trials are handled, how prosecutors approach trials differently in different jurisdictions. And it really comes down to who the prosecutors are, who the judge is, and the different types of maneuvering that is taking place. And so in the last video that I did on this case, they were basically setting up a schedule for when motions needed to be filed. They're trying to move quickly to trial, and so they set these deadlines on when the defense can challenge some of these charges, challenge some of the discovery, to put in their own motions, to have things striked from the indictment. And it just shows, when you look at the R. Kelly case, like there is just a total difference in what is going on. And so I believe that was back on the beginning of March when they set this schedule, of how things were going to take place. And then on April 30th, Tim filed a motion asking for an extension of time. And so let me read that one for you. Let me make sure I have the right case up. Okay. So this one was defendant's request for an extension of time within which to file pretrial motions regarding initial challenges to the indictment, and request for an extension of time within which to file evidentiary motions. I don't recall seeing anything like this in the R. Kelly case. But it says, come now, defendant James Timothy Norman, by and through legal counsel of record, Ethan B. Corleia and Joseph M. Hogan, and respectfully request that this honorable court extend the deadlines for filing any pretrial motions regarding challenges to the indictment and substantive evidentiary motions. In support of defendant's motion, legal counsel states as follows. 1. Pursuant to this honorable court's docket text entry and electronic minute entry dated March 2nd, 2020, the court set a deadline for pretrial motions regarding initial challenges to the indictment for Monday, May 3rd, 2021. Pursuant to the court's docket text order and electronic minute entry dated March 2nd, 2021, the court also set a deadline for evidentiary motions to be filed on or before Friday, July 2nd, 2021. Defense counsel has been in ongoing negotiations with the government regarding various discovery matters and issues. To date, defendant has not received the full extent of the government's discovery relating to the case, mainly due to the inordinate volume associated with same. Defense counsel met in person for a scheduled meeting with Assistant United States Attorney Gwendolyn Carroll and Assistant United States Attorney Angie Dennis on Wednesday, April 28, 2021, in order to facilitate and continue the ongoing discovery process. It was indicated to defense counsel that the government will continue to supplement pretrial discovery on a continuing basis to defense counsel. Defense counsel files the instant motion without objection from the government pursuant to discussions with Assistant United States Attorney Gwendolyn Carroll and Assistant United States Attorney Angie Danis. Defense counsel respectfully requests an additional 60 days from the designated deadline dates of May 3rd, 2021 and July 2nd, 2021, respectively, in order to file any potential challenges to the indictment and proper evidentiary motions. Defense counsel has been reviewing discovery material which has been conveyed to the defendant by the government on an ongoing and continuous basis. Pursuant to the court's order dated October 19, 2020, the court made a finding that the instant case is a complex case as defined in Title 18 United States Code Section 3161 H7BII. Therefore, the court entered in that order trial of the case should be continued past the limits set by the Speedy Trial Act, Title 18, United States Code Section, and goes through all that again, because the end of justice are served by continuing the case and outweigh the best interests of the public and the defendant in a speedy trial. The case is so unusual and complex that it is unreasonable to expect adequate preparation for pretrial proceedings within the confines of the Speedy Trial Act. And then it gives the code again. And then I want to put a pin here, because this is basically what happened in the R. Kelly case. I know a lot of people say, his speedy trial rights have been violated, but in fact they haven't, because he waived his rights to a speedy trial. And it was basically for these same reasons, that the case is so complex, that there's all this discovery, that there was no way that they could go to trial within the designated time. So wherefore, defendant, by and through legal counsel, respectfully requests that the court enter an order extending the deadlines for filing pretrial motions regarding challenges to the indictment, and that the court also extend the deadline for filing evidentiary motions, each for an additional 60-day period, respectively. Ethan Corleia, and then attorney for Tim Norman. So the judge then went in and entered an order, saying, as to James Timothy Norman, it is hereby ordered that defendant's request for extension of time within which to file pretrial motions regarding initial challenges to the indictment and request for extension of time within which to file evidentiary motions is granted. It is further ordered that the defendant shall have until July 2nd, 2021 to file initial challenges to the indictment. The government shall have until July 16, 2021 to respond. It is further ordered that defendant shall have until August 31st, 2021 to file evidentiary motions or a notice of intent not to file pretrial motions. The government shall have until September 14, 2021 to respond. Response to court due by 7/2/2021, which was July 2nd. Criminal pretrial motion due by August 31st. And then it was signed by the magistrate Judge Nanette A. Baker on May 3rd, 2021. And so here it is, July 2nd, Tim filed another motion, to have more time. And so in that motion, he stated, let me see. It says, defendant's unopposed request for extension of time within which to file pretrial motions regarding initial challenges to the indictment and request for an extension of time within which to file evidentiary motions. And this actually came from the prosecution, and it was a pretty long document, and so we'll try and get through this as quickly as possible. No, actually, this came from Tim's lawyer. Let's see what he had to say, but it still was kind of long. Let me get back up here to the top. Bear with me here. Okay, so it says, the defendant, James Timothy Norman, hereby moves this honorable court for a 90-day continuance of the deadlines to file motions challenging sufficiency of the indictment and evidence in the above captioned matter. Further, defendant requests to exclude the time within which the motions must be filed from the Speedy Trial Act on the basis that the ends of justice, and we already heard that whole spiel in the last, it says defense counsel have consulted with the government's counsel, and the government's counsel does not oppose the defendant's motion to extend the deadlines 90 days and also to exclude the time to the next deadline dates from the Speedy Trial Act. In support of defendant's motion, defendant states as follows. Defendant is charged via indictment, document 80, with murder for hire conspiracy in violation of Title 18, blah, blah, blah. United States Code and wire and mail fraud, conspiracy in violation, and then it gives the United States Code under Title 18. Pursuant to this honorable court's docket, text entry, and electronic minute entry dated May 3rd, 2021, the court set a deadline for pretrial motions, and then it goes through all the different dates and the changes that they made. Defense counsel have been in ongoing discussions with the government regarding various discovery matters and issues. To date, defendant has not received the full extent of the government's discovery relating to the case, mainly due to the inordinate volume associated with same. Defense counsel files the instant motion without objection from the government pursuant to discussions with Assistant USA Angie Danis on July 2nd, and they talked by telephone. Defense counsel respectfully requests an additional 90 days. Designated deadline dates of July 2nd and August 31st, respectively, in order to file any potential challenges to the indictment and proper evidentiary motions. Defense counsel have been reviewing discovery material which has been conveyed to the defendant by the government on the ongoing and continuous basis. And you see how this is different in the R. Kelly case, because all this time he's been locked up for 2 years. He hasn't been meeting with his counsel to go over discovery as the discovery is being turned over to the defense. And although Steve Greenberg claimed that he wasn't getting any of the discovery, we know that not to be true, that they were giving him discovery. It just wasn't the bulk of the discovery, that he needed the most, but he still could have been meeting with R. Kelly to discuss what he was receiving. And so it says, pursuant to this court's order dated October 19, 2020, the court made a finding that the instant case is a complex case. And so we already talked about that earlier. And then they go on to the argument, and it says, as a general matter, any case in which a plea of not guilty is entered by a defendant charged in an indictment with the commission of an offense must commence within 70 days from the filing date. And they're going over the speedy trial rules. He says Section 3161 of the Speedy Trial Act sets forth certain periods of delay which the court must exclude from computation of time as is relevant to the motion for extension of time pursuant to subsection 7A. The court must exclude any period of delay resulting from a continuance granted by any judge on his or her own motion or at the request of the defendant or his counsel, or at the request of the attorney for the government, if the judge granted such continuance on the basis of his or her findings that the ends of justice served by taking such action outweigh the best interests of the public and the defendant in a speedy trial. The provision further requires the court to set forth its reasons for finding that any ends of justice continuance is warranted. And then it goes through the subsections and it says, sets forth a non-exhaustive list of factors that the court must consider in determining whether to grant the ends of justice continuance, including whether the failure to grant such a continuance in the proceeding would be likely to make a continuation of such proceeding impossible or result in a miscarriage of justice, whether the case is so unusual or so complex due to the number of defendants, the nature of the prosecution, or the existence of novel questions of fact of law that it is unreasonable to expect adequate preparation for pretrial proceedings or for the trial itself within the time limits established by this section, whether the failure to grant such a continuance in a case which, taking as a whole, is not so unusual or so complex as the defendant reasonable time to obtain counsel would unreasonably deny the defendant or the government continuity of counsel, or would deny counsel for the defendant of the attorney for the government the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. And so going back to the R. Kelly case, we know that he's had a shakeup of his counsel, and that, the only extension he's been able to get has been a week in the trial date that was set. But here they are asking for like a 90-day continuance. And this is one of the points that they're making to justify why this should be allowed. And so it says, importantly, in setting forth the statutory factors that justify a continuance under subsection H7, Congress twice recognized the importance of adequate pretrial preparation time. And then it gives some cases that cites that. And it says, an interest of justice finding is within the discretion of the court. And then it gives some more cases. United States versus Hernandez from 1988. The substantive balancing underlying the decision to grant such a continuance is entrusted to the district court's sound discretion. United States versus Rice. In this case, the ends of justice continuance is warranted under 18 U.S.C. Section 3161 H7A, based on the factors described, and then they give some more codes. The case is extraordinarily complex, developing a system for storing and searching, producing, and or making available voluminous materials accumulated across hundreds of investigations and investigative leads, and ensuring that such a system is workable for both the defense team and defendant has taken time. It has taken an inordinate amount of time to load, process, search, and carefully review discovery materials. Further, adding to review time, certain sensitive materials have been redacted, restrictions on discovery dissemination have been followed, and still other materials have been filtered for potentially confidential information before they are reviewed by defense counsel or other members of the defense team. The need for reasonable time to organize and review voluminous discovery is among multiple pretrial preparation grounds that courts of appeals have routinely held sufficient to grant continuances and exclude time from the Speedy Trial Act. And then it goes on and it gives a couple of more cases. Upholding ends of justice continuances totaling 18 months in a co-defendant healthcare fraud and money laundering conspiracy case, in part because the district court found a need to permit defense counsel and the government time to both produce discovery and review discovery. United States versus Bell, upholding two separate 2-month ends of justice continuances in a firearm possession case where 5 days before trial a superseding indictment with 4 new counts was returned. 1,000 pages of new discovery materials and 8 hours of recordings were provided, and the government stated that it needed more than 5 days to prepare to try the defendant on the new counts. United States versus Vernon. District Court did not abuse its broad discretion in case involving conspiracy to commit wire and mail fraud by granting 2 ends of justice continuances due to voluminous discovery. And so it goes down with a long list of various cases and showing different reasons why more time was given, for continuances in dealing with discovery and having time to review that discovery and to write motions, in objection or, to the discovery, to have the indictments or charges on the indictment stricken and that type of thing, or to, discredit some of this evidence that the government had. And so they have this long list of cases where they're showing that this is, more of the norm instead of the exception. So then it goes down and it says, in sum, due to the volume and nature of discoverable materials and the reasonable time necessary for effective preparation by all parties, taking into account the exercise of due diligence, the failure to grant such an extension in this proceeding would be likely to make a continuation of this proceeding impossible or result in a miscarriage of justice. Accordingly, the ends of justice served by granting defendants' requests for an extension of time to file motions challenging the sufficiency of the indictment and evidence outweigh the best interests of the public and the defendant in a speedy trial. Wherefore, the defendant respectively requests that the court grant the motion for a 90-day extension of the deadlines to file motions challenging sufficiency of the indictment and evidence in the above captioned matter, and that the court exclude the time within which same must be filed under the Speedy Trial Act, on the basis that the ends of justice served by taking such action outweigh the best interests of the public and the defendant in a speedy trial. And then he signs off on that, and there's a certification of service, basically showing who all received the information. And then he also there was also an order included that says, based upon the representation in the defendant's unopposed request for extension of time within which to file pretrial motions regarding initial challenges to the indictment and request for extension of time within which to file evidentiary motions, and upon consideration of the entire record, it is hereby ordered that the defendant's unopposed motion request for extension of time within which to file pretrial motions regarding initial challenges to the indictment and request for extension of time within which to file evidentiary motions is granted. It is further ordered that the deadline currently scheduled for July 2nd, 2021 for motions to challenge the sufficiency of the indictment is continued. And actually, let me go back and I can read what those dates are that they filed. Hold on a second, guys. I lost my place. Okay, actually, I'm going to read the government's response to that motion, and then I'll read what the judge ruled. And so it says, government's response to defendant's request for extension of time within which to file pretrial motions, document 140, comes now the United States of America by and through attorneys Saylor Fleming, United States Attorney for the Eastern District of Missouri, and Angie E. Dennis, Assistant United States Attorney for said district, and files its response to defendant's request for extension of time within which to file pretrial motions. On July 2nd, 2021, counsel for defendant James Timothy Norman filed an unopposed request for additional time to file pretrial motions. While it is accurate that the government does not oppose said request, the government wishes to clarify the record in regard to the discovery in this matter. Counsel represented that defense counsel have been in ongoing discussions with the government regarding various discovery matters and issues. To date, defendant has not received the full extent of the government's discovery relating to the case, mainly due to the inordinate volume associated with same. This is an accurate representation, and counsel for Norman has frequently communicated with the government with regard to the organization, volume, and complexity of the discovery in this matter. However, the government wishes to clarify that it has made the entirety of the discovery in this matter available, reaching out to counsel on April 12, 2021, May 11, 2021, and June 22, 2021, requesting a hard drive on which to place the items that constitute Volume 4 of the Discovery production. Furthermore, on or about April 28, 2021, the government conducted a reverse proffer with counsel, explaining to them the evidence against Norman and where in the various productions to locate many of the documents the government referenced during the meeting. As of the date of this writing, the government has not received a hard drive from counsel for Norman on which to load Volume 4, so they do not yet have it in their possession. Once counsel for Norman provides said hard drive, they will immediately receive the remaining discovery related to the matters for which Norman stands charged. The government does not oppose counsel's motion for an extension, but simply provides this correspondence in order to clarify the record with regard to the production of discovery. And that was signed by Sailor Fleming and Angie E. Danis. And so the judge responded, and in her response, she stated, scheduling order, all pretrial matters in the above referenced case have been referred to the undersigned United States Magistrate Judge pursuant to 28 U.S.C. 636B. On December 3rd, 2020, the undersigned granted the government's motion for complex case finding and to continue trial date beyond limits set by the Speedy Trial Act, and finds no reason to disturb that conclusion. This matter is now before the court on defendant James Timothy Norman's unopposed request for extension of time, which to file pretrial motions regarding initial challenge to the indictment and request for extension of time within which to file evidentiary motions, filed July 2nd, 2021. For the reasons stated in defendant Norman's motion and taking judicial notice of the government's response filed on July 6, 2021, the undersigned will grant defendant Norman's request accordingly. It is hereby ordered that defendant James Timothy Norman shall have until September 30th, 2021 to file any challenges to the indictment, and the government shall have until October 14, 2021 to respond. It is further ordered that defendant James Timothy Norman shall have until November 29, 2021 to file any evidentiary motions or notices of intent not to file pretrial motions, and the government shall have until December 13, 2021 to respond. It is further ordered that the deadline set forth in the court's order dated May 4, 2021, remains set as to defendant Terica Tanisha Ellis, to Wael Rabhi Yagnan, and Travell Anthony Hill. The deadline for defendants to file any challenges to the indictment has passed, and the deadline to file evidentiary motions remains set for August 31st, 2021. And so, you guys, as you can see, Tim is, requesting these extensions, saying that he needs more time to review this discovery, but it looks like the other three defendants, they seem to be okay. They're sitting back waiting to see what happens with Tim, and they are pretty much banking on, if Tim is found not guilty, then they are all going to be found not guilty. And I hope that strategy works out for them. And so one more thing I want to point out before I leave. In several of my previous videos, I talk about the fact that the defense is not challenging these charges on the indictment. Why are they not, challenging discovery? And please forgive me if you're listening, because I can't remember which one of the people that follow my coverage of the R. Kelly case pointed this out. But he was saying, I believe it was Robert Keller. I believe it was him. But he was basically saying that Steve Greenberg had filed a motion to dismiss charges a while back. And the truth is he did. And I did a video on that. However, his motion was to dismiss all the charges. It was around the time when they added Aaliyah to the case. And then he filed to strike the superseding indictment, you know, on the basis of the new charges of Aaliyah. And he really didn't break down charge by charge by charge why these things should, you know, be removed and these charges should be dropped. And that's what I'm talking about when I say that the defense is not filing motions to, you know, get some of these charges dropped from his case. And you can basically, and I've talked about this before, you know, with my kid's father, you know, who is currently in prison. And I've mentioned this before, how he was initially arrested on a 34 count indictment. And before his trial started, they had already wiped out, you know, like 11, 12, 13 of the charges against him. And then by the time the case went to the jury, they knocked out another 11 counts. So by the time he was actually found guilty in his case, he was only facing like 11 of those charges, of those 34 charges were remaining. And so that's what I'm talking about. Like, they need to be challenging each one of these charges against him separately. Like, you know, we need this stricken, we need this stricken, we need this stricken. And then in addition, there haven't been any motions regarding the discovery, and that's probably because Steve Greenberg had not gone over the discovery with Mr. Kelly at all, okay? And so now that his new set of attorneys is trying to go through this discovery with him, they need time to be able to put in motions to strike some of this discovery after they talk to him. If he says something like, I don't know that person, I wasn't at that location at the time that that person says that I was at that location. Those are the type of things that they need to be trying to argue and defend. And it makes no sense that this trial is about to start, that R. Kelly's trial is about to start on August 18th. And none of this stuff has been challenged against him. So that's what I'm talking about when I keep saying, why are they not challenging these charges? Why are they not challenging this discovery that's being put out there? And it's simply because they don't have the time right now with his new attorneys. They really don't have the time to start challenging this stuff because they haven't met with him to go over any of this stuff. And so I don't understand how this trial is going to start on August 18th under these conditions where he has not had the opportunity to challenge this stuff, you know, with the past counsel that he had who wasn't doing their job. And that should be a reason for Judge Donnelly at best to, or at least give like a 90-day continuance in this case so that they can do that. And so I just want to show you guys this juxtaposition in how these cases are being handled and how, the courts have leeway to do exactly what they want to do when they want to do it, if they want to do it. And it is obvious that they don't want to give R. Kelly a fair trial, allow him to properly prepare for his case, just not listening to him, not... and I go back to those motions that were filed in the Chicago case where the person was saying that they wanted to remove Steve Greenberg from the case. That was like a year ago. And how Greenberg was able to go to the judges and tell the judges, oh, disregard those motions. We don't know who that person is, who's filing those motions, so disregard them. And the courts don't appear to have ever went to him and say, do you know who's filing these motions for you? Is this what you want? Is this what you believe? Instead, they just took Greenberg at his word and just started denying the motions. And so to me, that in itself is unfair to him as well. So just want to bring this information to you guys, just to show you this comparison. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.